The shocking outcome of the Altantuya murder appeal in the Court of Appeal yesterday has the effect of bringing further and total disrepute to the Malaysian criminal justice system. Keadilan has always maintained that the Altantuya High Court trial of Razak Baginda, Chief Inspector Azila Hadri and Corporal Sirul Azhar Umar has always been a manipulated process and done according to a prescribed script. When the script was not followed at certain points in the initial stages, we saw the fallout. For example, the most senior prosecutors in the prosecution division of the Aegis chambers at that time, such as Dato' Salehuddin and Dato' Yusof Zainal Abidin, were removed from the team when they refused to play ball with the script that would result in the certain acquittal of Razak Baginda. Salehuddin then resigned to go into private practice. We also saw the trial moved to be heard before Yang Arif Zaki Yassin, after Yang Arif N. Segra refused bail to Razak on the basis of facts stated in Razak's own affidavit. The movement of this trial was of course disguised in a reshuffle of cases in the Shalam High Court. There were still occasional out-of-script movements during the trial when a witness, her name is Buruma Oin Chimek, alias Amy, she tried to tell the court about the photograph shown to her by Altantuya showing Razak Baginda, Prime Minister Najib and her in a restaurant in Paris. And she was stopped by objections, and this is the interesting part. Objection from the prosecution, no, from the defense, which is understandable, also from the prosecution and also by the court. So, but of course the rest of the trial mostly played out according to the written script, including the acquittal of Razak Baginda. Parti Keadilan has also consistently maintained at all times that key witnesses such as DSP Musa Safiri, Nasir Safa. Nasir Safa, by the way, is the Private Secretary of Prime Minister Najib for a long time, almost 20 years. Prime Minister Najib himself, his wife Rosma and his brother Nazim Razak should all have been called as relevant witnesses. Not so much to establish the guilt of Sirul and Azila. For us, the guilt of Sirul and Azila has not been an issue, but really more to establish who had directed Sirul and Azila to kill Altantuya. Especially after the revelations of Deepak Tetwani and Emmerich Singh Sidhu, it is obvious that all these names we have mentioned just now and Cecil Abraham are also relevant witnesses. Private investigator Bala Subramaniam, who is now deceased, had in his public statements earlier detailed Musa's involvement. This is Musa Safiri, Musa's involvement in the episode and the link between Musa and Razak Baginda. The key question to be answered was always who was directing Musa, as Razak Baginda clearly has no authority to direct key police personnel. You must remember Razak Baginda is just a civilian. Yeah. So who can order a DSP, to do things? Who can order people like Sirul and Azila who are UTK, specialized police personnel, to do things? Musa at that time, we must remember, was Najib's ADC. Now we have another personality, Nasir Safa. He is Prime Minister Najib's private secretary of 20 years standing at the material time, no more the secretary. He was identified by P.I. Balasubramaniam as present on the night of the murder, on 19th October 2006, in front of Razak Baginda's house in Bukit Damansara, driving around slowly, surveying the scene, before Sirul, Azila and woman policeman Lance Corporal Rohaniza Roslan arrived later to take away Altantuya, who was in front of the house with Bala. Now, so Najib, Rosma and Nazim have all been implicated by public statements by Bala Subramaniam, Deepak and Emmerich Singh Sidhu in the making of Bala's second FD, which was done to obliterate all references to the alleged relationship between Najib and Altantuya in Bala's first FD. So, when the High Court judge, Yang Arif Zaki, this is the High Court trial, when he said he had a problem establishing motive, it will be obvious to all and sundry that witnesses such as DSP Musa, Nasir Safa, Prime Minister Najib, his wife Rosma, his brother Nazim, Deepak Tetwani, Cecil Abraham amongst others would be highly relevant to motive. But of course, none of them were called to give evidence during the trial. bears that responsibility? Who bears responsibility for conduct of the trial? None other than Gani Pacha, the Attorney General. The acquittal of Razak Baginda in the High Court in the first part, without his defense being called, was highly questionable. Also questionable was the decision of the AG to not appeal. We know as lawyers, the AG's chambers routinely appeals verdicts against them in criminal trials. The AG's chambers had also made repeated and consistent public statements that they had a very good case against Razak. So why then did they not appeal? It is our view that there was sufficient evidence during the trial to convict Azila and Sirul on the evidence of Bala, Lance Corporal Rohaniza. There were phone records showing the constant communication between Azila and Razak Baginda from 18th October before and after the murder. The fact that Altantuya's jewellery was found in Sirul's house. The fact that there is CCTV footage in Hotel Malaya where Altantuya was staying on 18th October showing Sirul and Azila's presence there. So in other words, the link between these two policemen and Altantuya is not just on the night of the murder when they come and take her away in front of Razak Baginda's house. 2 days before, 1 day before, they are surveying her in Hotel Malaya. There is CCTV footage and that is in the court. Altantuya's blood stains on slippers in Sirul's car. Although they're making a big issue about the fact that the slipper is oversized and not his size. People quite often wear big slippers. But the point is there was her blood on the slipper in his car. The use of C4 explosives and other evidence. And one I want to stress here which is not mentioned in the written statement. The unsworn statement made by Sirul in court itself, which implicates Azila totally. So when the Court of Appeal starts talking about there's some log about Azila in Bukit Aman showing he's there. I mean, quite clearly the High Court judge had no problem with that because Sirul is there giving a statement and implicating Azila wholesale. And Azila does not take the stand, does not give unsworn evidence, does not take the stand and give any kind of sworn evidence. So for the judge it's very easy to come to the conclusion. Azila doesn't take the stand to explain anything and leaves it to the evidence in front of the court. So, sorry if I may continue that. So it is our view there can be no doubt that Sirul and Azila were the last to be seen with Altantuya. So convicting Sirul and Azila is not really an issue. And we are saying today that even if the Court of Appeal found defects in the manner the High Court judge analysed the evidence and in the conduct of the prosecution in presenting the case, the proper order to make in this case is to order a retrial and not grant an acquittal. Particularly when the defect was there, a key witness such as Musa Safiri was not called. There is plenty of power under the law. In Section 60 of the Courts of Judicature Act 1964 to order a retrial. And you can ask lawyers who do criminal law practice, they will tell you that this is regularly done in criminal appeals. This is nothing new, nothing unusual. It is quite common for an appeal court to say, we find something wrong in the High Court process or the lower court process, but we are not acquitting, we are sending it back for a retrial. Because criminal trials are not like civil disputes. Criminal trials have a big public interest dimension. You cannot simply just throw everything out just because of some technical thing. Civil cases you can do that, or you're more open to doing that. So the correct thing should have been done yesterday was to order a retrial. But today what we want to stress, and this is our key point today, is that the judgment of the Court of Appeal, especially when it highlights aspects of the shoddy prosecution, highlighting in particular the omission to call Musa Safiri. However, the omission is not just to call Musa, but also the many others stated above: Musa, Nasir Safa, Najib, Osma, Nazim, Deepak, Cecil Abraham, amongst others. The question raised by the Court of Appeal about the failure of the prosecution to call a key witness, Musa Safiri, is only one of the many questions to be asked about this failed prosecution. Any independent investigator would be asking why persons linked closely to Najib, such as Musa Safiri and Nasir Safar, are linked to this murder. Najib's direct involvement in the making of Bala 2nd SD, which is confirmed through Emmerich Singh Sidhu and Deepak, raises questions about his motives. Party Cardinal therefore calls for a Royal Commission of Inquiry into this failed prosecution. We had already earlier called it a failed prosecution because of the acquittal of Raza Baginda, which we find cannot be justified, and the gross failure to identify and prosecute those who directed the killing of Altantuya. However, now this failed prosecution has taken a ludicrous twist with the acquittal of Serul and Azira, as now the Malaysian criminal justice system sinks into complete disrepute in the eyes of the world. A Royal Commission is necessary to start the process of rescuing its credibility. So we end with the question, will the Cabinet sit, the Barisan National Cabinet sit, of course without the presence of Prime Minister Najib, and make this decision? So this is our call, that this is the only way to rescue this situation, where I think you will see yesterday, just from the social media world, the discussion in the social media and the internet, the criminal justice system of Malaysia is now seen almost as a joke, that this sort of manipulation can be done.